Hello everyone. This is a important video regarding the eviction ban and the foreclosure ban that's been in effect since March, imposed on us by our governor. And a lot of landlords and investors and housing providers and commercial real estate owners have been talking about this. I've been talking about it with them a lot. And everybody that I meet, I say, why isn't there a class action lawsuit yet? I'm surprised that it hasn't happened. And we've all been talking about what the legal theory would be to get relief in this pandemic. So there's been so many different orders and different moving parts. And I've been speaking with a lot of lawyers around the state of Indiana, as well as looking at litigation that's occurring in other states. And I think what's finally starting to coalesce is maybe three different legal theories to get relief and stop this ban on evictions and stop the ban on foreclosures, which are affecting landlords and bankers and creditors, private lenders all over the state of Indiana. So there's a lot of people affected by this, and they've been, frustrated, right, with the lack of response and the inability to feel like you can do something. So I'm going to give you three broad categories of legal theories that I think could work, and one of these, or two of them really, are already being used over in Ohio. So I want to congratulate my brother and sister lawyers in Ohio for starting some of this litigation. And a third theory that we've come up with, and nobody's used it yet, but we need to try to throw the book at it and see how many different ways we could get relief. So constitutionally is the first set of the three types of legal theories. And under the Constitution, we have something called the Takings Clause. The Fifth Amendment says you cannot take property from people without compensation. So we usually see this in eminent domain and condemnation, or inverse condemnation cases as well. And there's a lot of ways to approach it. So that'd be the first one, a Fifth Amendment takings case. Another theory within that, and closely related, would be a due process, that you can't do these things, these orders, executive orders from the governor, without due process, an opportunity to be heard, an opportunity to state your claim and have it adjudicated in a court. So these new wide-ranging rules and executive orders by the governor have not been vetted through due process. Closely related to that is the Equal Protection Clause argument, and that is applied to the states by the 14th Amendment. So equal protection says everybody gets the same legal result, and the governor or a state agency can't pick and choose and say, oh, we're going to single out one or two types of causes of action and stop them without treating all litigants the same way. That's equal protection. So that'd be another theory. The governor of Indiana, at least, is operating under executive power that was granted to him by statute in the legislature back when the financial crisis hit. And so he's asserting a lot of power under that. It's never been tested. And another constitutional protection is to say there may be a statute, but is it valid or not? And in this case, there's two reasons it would not be valid. Either the statute is void for vagueness because it's given a vague grant of power, or the power is so overly broad that it's vague or that it's void for constitutional analysis. And so you have to take the statute, apply it to the constitutional standard, and say it's void and the governor's acts are therefore illegal and unconstitutional. So there's 5 different ways that we've described that are potential causes of action, and those are being used by some of the amusement parks, Kings Island and whatnot, over in Ohio in their litigation. There's another constitutional provision or a Supreme Court authority that could be used, and this is called a writ of Mandamus. So this is the second main legal theory that's being attempted over in Ohio, at least, and that was filed recently. And it was called a writ of Mandamus and writ of Procedendu. So these are orders or requests by the litigating party, by the plaintiff, saying, Supreme Court, we want you to order something to happen. We want you to order the process to move forward, the procedendum, and we want you, Supreme Court, to tell all the lower courts that they need to get back to work and do what they're supposed to do, which is handle foreclosures and evictions. And Ohio is a little bit different than Indiana because it's more on a county by county basis what's happened. So look at it that way. That's another legal theory that's being tried, this writ of mandamus, writ of procedendum, directly to the Supreme Court of Ohio, asking them to enter into an order. The final legal theory that I want to raise to you today is what's called tortious interference with a business relationship. And in this case, you might say that in a normal plaintiff and defendant, if one party is interfering wrongfully in another person's business, there's a cause of action called tortious interference with a business relationship. And in the case at bar, what we would say is, has the governor of the state of Indiana tortiously interfered with the business relationship of all the landlords and all the creditors that need to be filing evictions or filing foreclosures, and is it causing them damage? And that's a tort. It's a wrongfulness, right? Normally a tort you would think of as a car wreck where you've been negligent in driving your car and you've wrecked it, you hit someone, you caused them damage. It's a civil wrong. And tortious interference is another independent legal theory that could be pursued. So all the landlords, all the commercial property owners, all of the creditors who've got loans that they need to foreclose on, these are all legal theories that might be pursued in lots of different avenues in all the state courts. They could even end up being a class action, I would think. And I'm reporting on that kind of here. I'm starting to see this in Ohio, not seeing it yet in Indiana, but perhaps investors will band together and pursue this kind of litigation. Specifically, you might have noticed in the news this week, Simon Property Group filed a lawsuit against Gap Inc. for like $65 million for all the Gap leases that are being defaulted on throughout the country in over 300 of the malls. So they might be defaulting on and pursuing those cases not on eviction basis, but just on the underlying breach of the lease as well. So they might not get possession yet, but they might be just pursuing the litigation on the breach of the lease for money damages right now and pursue the eviction later. We'll see how that turns out. I'll keep you posted. I wanted to give you that update. Hope you enjoyed it. If you got a question, give us a call. We'd love to help and answer that or kind of round table this more with you. Thank you.